Hi everyone, my name is Joyce and I'm the Communications Manager at TechSoup Canada. I'd like to welcome and thank you all for joining us for today's webinar on Canada's anti-spam legislation. Before we get started, I do want to quickly introduce you to TechSoup Canada for those of you who aren't familiar with us. So TechSoup Canada's mission is to help nonprofits use technology effectively, and we accomplish this in two ways. The first is to make technology products more affordable through our technology's donation program. The way we do this is we partner with corporations such as Microsoft, Adobe, Symantec, and 30 others to offer their products as either an outright donation or at a significant discount for charities, nonprofits, and libraries across Canada. For example, if you would like a copy of Microsoft Office Professional, you can purchase it for about $500 in store. But if you are a TechSoup Canada member and you qualify for the Microsoft Donations Program, you can get Office Professional for about $56. So as you can imagine, the cost savings can become quite significant if you're purchasing software for your entire staff. Creating a TechSoup Canada account is free, so if you'd like more information, visit our website at techsoupcanada.ca/getting started. The second way we try to help nonprofits use technology effectively is to create and curate nonprofit tech resources. We write and curate blogs on social media. We host events and webinars, such as today's session, to help nonprofits learn more about the technology that impacts their operations. So if there is a topic you would like to learn more about, please let us know. TechSoup Canada is also a program for the Center for Social Innovation and a member of the TechSoup Global Network. For today's webinar, you can use the GoToWebinar panel on your right-hand side to enter your questions or chat with us. Just a reminder that you are on mute, so if you have any questions or concerns, chat to us in the question box and we'll do our best to help. As a reminder, this webinar is being recorded and will be uploaded for later viewing, and you can download the webinar slides under the handout menu on your GoToWebinar panel. Today's presentation is quite packed, so if time allows, we will do a Q&A period at the end of the presentation where I'll ask Maanit your questions on your behalf. If we run out of time, you will have an opportunity to indicate on the post-webinar survey that you'd like to hear more from Maanit. So now it's my absolute pleasure to introduce our guest speaker, Maanit Zemel. And I want to let you guys know that I am seeing your comments, and I believe this is just my audio on my end, so I'm so sorry. But once I pass the presentation over to our speaker, the audio will be much, much clearer. Again, to introduce our speaker, Maanit is a lawyer and co-founder of Zemel van Kampen, a technology law and litigation boutique law firm in Toronto. She has substantial experience and expertise in internet law, including Canada's anti-spam legislation, online defamation, cyberbullying, as well as commercial litigation involving domestic and international disputes. Maanit has advised numerous nonprofit organizations and charities, including large umbrella organizations, on CASL compliance, and has drafted their template compliance policies. In addition to her law practice, Maanit is a part-time member of the Ontario Landlord and Tenant Board, where she adjudicates disputes between residential landlords and tenants, and she also teaches business law at Ryerson University and the University of Toronto. So without further ado, I'm going to pass the presentation over to Maanit. Okay, Maanit, can you try advancing the slides and speaking?
Yes. Hi, can you hear me?
Yes, I can hear you.
Great. Okay. So, hello everybody, and I believe my audio is okay. Is that okay, Joyce? Can you confirm that you can hear me?
Yeah, I can hear you fine. So, the audience, if you can just chat to me. Yes, they have confirmed. You're much better.
Yes. Okay. Yeah. All right. Thank you so much. So, welcome everyone. There are very large numbers. I was telling Joyce, I don't think I've spoken at many various seminars and webinars, and I have never spoken to this number of people at one time. So go technology, this is amazing. Okay, so we only have an hour, which is very little time to cover everything I want to cover. So I'm just going to delve right into it. Thank you again for the intro, and thank you for hosting this, TechSoup Canada and Joyce. You heard a little bit about me. I'm just going to, in case there's any confusion, I'm just going to make it clear that when you sign up and mention that I'm a founder and I work for a firm called MTZ Law, I have just we merged with another firm, and now we are Zemel van Kampen LLP, which is why the name's changed. So if you go out there and you look me up and it turns out it still says MTZ Law. It's just because we haven't yet set up our website. But other than that, that's my new firm. Okay, so let's delve right into it. So let's talk about Canada's anti-spam legislation, or CASL. I gave a similar presentation 3 years ago through Text of Canada, and it was about how to prepare for CASL as of July 1st, 2014, which is when CASL came into force. We now flash forward 3 years. Some stuff has happened. Now we know a little more, not that much more, but we know a little more to give some more information about CASL. But also there's a couple of important, well, there's one key date that's coming up, and that's July 1st, 2017. And it matters for a couple of reasons, which I'll delve into, which is why this is a very good opportunity for all of you that do not know about CASL to learn about it. And those who have, but want to know what's happening in the next, coming up in July, you'll find out as well. So again, I'm going to go right into it, and I am apologizing because I doubt we're going to have very much time for questions, and I'm happy to deal with it directly with any of you who want to get in touch with me later. Okay, so without further ado, here we go. Is it, okay, let me see. All right. Okay, I am a lawyer, so there's a quick disclaimer there that, you know, you can see that this is not legal advice, and please don't take it as such. This is purely informational. I got to do it. I am a lawyer. Okay, next one. Yeah, there we go. Okay, so let's talk about what we're going to talk about today. First of all, I'm going to give you an overview of CASL. I'll then give you, I'll discuss what are commercial electronic messages, or CEMs. Then I will focus on the charities exemption, which, yes, I know many of you are not charities, you're nonprofits, and that's okay. I will be talking, to those of you who are concerned, I will be talking about nonprofits as well specifically, but charities do have a special exemption that applies to them, and we're going to have to, and I'm going to be focusing on that. And finally, I'll give very brief recommendations on, or sort of take-homes about stuff you need to think about and what you got to go, you know, what you should do from here. Okay, so. Yeah, all right, so, you know, this is a little intro I have to CASL. Okay, what is CASL? So CASL, as you can see that word anti-spam suggests that it deals with spam. That is quite misleading, because CASL doesn't just deal with what traditionally you would assume is spam, like that email from the prince from Nigeria who wants you to send him money because he's desperate. So it deals with much, much more than that. It deals with commercial electronic messages, and those are defined very broadly in the Act, which is why many people assume it doesn't apply to them. They think, oh, we don't send spam. Well, turns out under CASL you actually do, because everybody sends out commercial electronic messages in any capacity, both whether or not you're an individual, a charity, a business, nonprofit. Everybody sends out commercial electronic messages, which means that CASL applies to everybody, not just to the prince from Nigeria. So let's move forward. All right. So what is CASL? So as I mentioned, CASL regulates all commercial electronic messages, or CEMs, sent or accessed from a computer in Canada. So as long as it goes from Canada or to Canada in some way, some shape or form, CASL applies. There are other things that CASL regulates, such as installation of computer programs, misleading advertising and marketing practices online, privacy invasion via computer, and collecting email addresses without consent, or what we call email harvesting. But I'm going to be focusing on the first part, which is the CEM. It's the main part today. And I will also have a slide at the end that deals specifically with collecting email addresses without consent, because I find charities and nonprofits fall, you know, that little area of CASL they're not aware of. They actually tend to violate that without knowing. So if I have the time, I'll touch on it. If not, you will have these you have these slides available, and you can look at what it says at the last slide about the email harvesting. All right, so I'm going to start with the bad news, and then I'll go to the good news. I know I'm going to scare you a little, but it's just what I do. Okay, so I'm going to talk about enforcement of CASL. Why is that important? Because CASL came into force, as I mentioned, almost 3 years ago, July 1, 2014. And over the 3 years, CASL has been enforced by 3 regulatory bodies. The first one is the CRTC, which is the main regulatory body for CASL, and it's focused on what we are going to focus on today, which is the CEM component. The Privacy Commissioner also enforces CASL, and they've also taken some steps over the past 3 years, sorry, to deal with that. And one of the things they deal with, as I mentioned earlier, is the email harvesting. And then the Competition Bureau that deals with misleading online advertising and marketing practices, that less applies to charities and nonprofits. Right. Here's what we got to talk about in terms of what I mentioned I'm going to scare you. Well, why do you need to take CASL so seriously? Let's put it this way. Okay. Well, simply because if you don't and you violate CASL, there are very, very significant consequences that can arise from that. The first one is administrative monetary penalties, or AMPs, or I basically refer to them as fines. The CRTC says, oh, they're not fines, they're AMPs, but it's essentially the same thing. And CASL has the ability, well, the CRTC has the ability of imposing up to $1 million on an individual for violating CASL, and up to $10 million on a corporation or organization, so nonprofit as well, for violating CASL. Those are huge numbers, and that's why CASL is scary. There are other types of consequences that can arise from violating CASL, and those are some of the ones that are coming up on July 1, which is why you need to take this back and consider why you need to focus on July 1. So, as of July 1st, 2017, the private rights of action come into play. What is that? CASL says that from July 1st, 2017 onward, anyone can basically sue you, start a civil action in court for violating CASL. So if you click send and send an email to 1,000 people, that can turn into a class action of 1,000 people getting together and suing you for violating CASL just because you clicked send on an email that went to 1,000 people. So when you think of class actions, that ends up being potentially facing significant amount of damages, not to mention legal costs. So that's the kind of thing that you really need to think about when you're focusing on July 1, because while up until now you couldn't be sued civilly under CASL, that's going to change in a few months, and I can tell you that there are plaintiff lawyers, class action plaintiff lawyers, just sitting out there in the lurks waiting to start launching lawsuits, class action lawsuits against various organizations that have been sending emails. So keep that in mind. All right. The other thing that is important and why you need to take this back and talk to your superiors, your organization, your board, is because there is vicarious liability of the organization for its employees. So you employ staff, your staff, or even volunteers, they violate CASL unintentionally or intentionally, but at that point, while they may be in violation, so are you. So you got to be aware of that. And by you, I mean the organization. And of course, and then the other part is liability of officers and directors for acts of the corporation. So CASL imposes liability on officers and directors. Yeah, that means your CEO, that means your board of directors, for violations of CASL by the organization, by the nonprofit and the charity. And sweeping investigative powers. CRTC has really broad powers to come in and search and seize computers, et cetera, if they believe there's been a violation of CASL. So those are the kind of things you can face for violating CASL. Pretty serious stuff. Okay, so now let's talk about CASL enforcement so far. That's always one of the first questions I get. I go, well, what's happened in the past 3 years? Well, there's been some, some development. And let me step back for a minute and tell you what's going on. So first of all, and I didn't mention it earlier, but it's on my previous slide, one of the things that has been set up by the CRTC when CASL came into force is they set up this website called fightspam.gc.ca. And the intention of this website is to make it easy for anyone to complain. Okay, so basically, if you think of government agencies, especially in Ontario, if there's some issue that you have with whatever, you want to file a complaint, often you have to go stand in line, you have to fill out a form. A lot of people just won't bother. CASL is different. CASL is just simple. Okay, someone gets an email, they say, oh, I'm not happy about this. They'll just go to the website, and with a couple of clicks of the mouse, there's a official complaint filed against the organization, and that goes to the CRTC, and the CRTC will investigate and decide what to do about it. So the CRTC is very mum and quiet about how much complaints it has actually received. As lawyers who deal with CASL, we try to get information from them, but they're pretty, they keep their mouth shut. So, so I've been trying to find some information, and the most recent thing I found was back in February 2016. So that was about a year ago. About a year ago, it appears, and again, this is basically hearsay. This is through hearing from someone who had gone and spoken to someone at the CRTC, that they say that there was over 500,000 complaints filed, so 500,000 complaints filed under CASL with the CRTC back in February 2016. I'm not surprised by that at all. Okay, that actually makes sense to me. I would guesstimate, this is a real guesstimate, that by now it's close to 1 million. So no, maybe not 1 million, but certainly over 500,000 and somewhere in, in between that and 1 million. So a lot of complaints. Well, what does that mean? It means essentially the CRTC has to sift through all this stuff and figure out what is real, what is not, investigate it, and that takes time. But that being said, things are happening. As I mentioned, the CRTC is very quiet and doesn't share the information about what they're actually doing and what kind of organizations they're dealing with, what kind of complaints they're dealing with. All we have, though, is what they do make public. And what they make public is what they want to make public because they want to send a message. Okay, so what do we have that we know of because the CRTC has made public? First of all, there have been 2 decisions by the CRTC tribunal. So the CRTC tribunal is an administrative tribunal, and I sit on one, not on CRTC, I sit on an Ontario one, but essentially it's like a judicial body. Okay, it's one below a court, and they make decisions on CASL. And so there are 2 decisions that came in front of them and that reached that point because the individual or the company that was being charged by the CRTC or facing a penalty by the CRTC fought it. Okay, they didn't agree, they didn't settle, they fought it. And so they both lost, being the companies, the company and an individual who were fighting it at the tribunal level. And the 2 decisions we have is, first of all, actually only about a few weeks ago, a decision came out in the Rapanos case, and that's unusual because in that case, it was an individual, not a company, not a business, but an individual who was facing a fine for sending emails out. And he was facing a $15,000 fine, which is a lot for an individual, even though technically he could be facing $1 million. $15,000 is a lot. I'm sure all of you would agree. And he was fighting it, and he lost at the tribunal level, and he now has to pay $15,000 in fines. Before that, there was another company called Blackstone. They were facing a fine by the CRTC, by the commission of $640,000. That's what the CRTC wanted to obtain. They fought at the tribunal level, and the tribunal reduced the amount to $50,000. So it was actually a kind of a win for Blackstone. But again, $50,000, a lot of money for any nonprofit or charity. So those are the 2 decisions of the tribunal. In addition to that, we know that there is a company in Quebec called CompuFinder that is currently facing a notice of violation of $1.1 million. That means that the CRTC is looking to get $1.1 million from them or to impose that fine, and they are in the process of fighting it. I don't know where it's gone, but it's somewhere in the fight level, in the litigation level. And then there are the undertakings. So undertakings are essentially settlements, agreements by the companies or the individuals who violated, organizations that violated CASL or be found to be in violation of CASL, and the CRTC. So they come to some form of settlement, and then they agree to make it public. So the 4 that we know of are Kellogg, Kellogg Canada. They paid a $60,000 fine. Rogers Communication paid a $200,000 fine. Porter Airlines paid $150,000, and Plenty of Fish, which is a dating site, paid $48,000. So again, a lot of money, a lot of zeros. Some of these companies can't, still a lot of money, but they can bear it. But if you think about yourselves and your organizations, those numbers are they're punishing. So now what? You're facing this and you think, oh my God, look at those numbers. What do you do? Well, what can you do if the CRTC is knocking on your door and saying, hey, someone has filed a complaint against you with the commission? Well, you can defend yourself. And the number one defense that you have, okay, which was called an absolute defense, meaning that if you can prove it, you are off the hook. You don't have to pay anything, and you are basically not found in violation of CASL, is what is called the due diligence defense. What is that? It is basically available to any organization that develops and implements a comprehensive and effective CASL compliance policy, and the CRTC has made that very clear. In other words, if you prepare for CASL, if you ensure that you have a policy, just like a privacy policy, okay, for example, I'm giving those of you I'm sure who have privacy policies will understand, a policy that is comprehensive. It means it covers everything and any issues that you that are essentially relevant to your organization, right, depending on the type of communications you have. But if you put together the policy and you thought it through and you planned it and you made it compliant with CASL and you implemented it, meaning that you not just wrote it down and put it on your website, but you actually put it into play, put the process into play to ensure compliance, and you trained your employees or volunteers, etc. Well, if you do all that and you show that to the CRTC when you're facing an investigation or a complaint, you may be successful in getting off the hook entirely and avoiding liability. So that's why a due diligence defense, and more significantly, a comprehensive and effective CASL compliance policy is so important. I highly recommend it, and I will get back to that later on at the end of my presentation. All right, so that's CASL intro and enforcement. Now let's talk about the nitty-gritty. Let's talk about commercial electronic messages, or what essentially the type of electronic messages that CASL regulates. So, what is a commercial electronic message? Well, a CEM is a message. This is me paraphrasing the very long and long-winded definition in CASL. Okay, CEM is a message sent by any electronic means. So it's not just an email. See, people assume it's emails. It's not. It also is a text, an instant message. It could always also be a tweet, although while then it is a tweet, it really is direct tweet to someone when you sort of target them. It's not just a tweet on your wall, on your Twitter account, on your handle. That has as its purpose, or one of its purposes, to encourage participation in a commercial activity. Okay, so very, very broad, and when it talks about purpose or one of its purposes, it talks about direct or indirectly. So as long as it's somehow, somewhere in behind the scenes, there's a purpose to encourage participation in a commercial activity, it's a CEM. So what is a commercial activity? Well, commercial activity is defined also very broadly in CASL, and it basically covers, again, I'm paraphrasing, any particular transaction, act, or conduct. So it's not just a transaction, not just an exchange, any act, any conduct, anything you do essentially, that is of a commercial character. And here's the key, and this is why I highlighted. The words are whether or not the person who carries it out does so in the expectation of profit. Why are those words important to you? Because what they essentially mean is that it applies to nonprofits. In other words, it's commercial character. Everybody thinks, oh, commercial means that we're not profit. No. Those words were added specifically and intentionally by the legislature to ensure that it covers anything done by nonprofits and charities. So that's basically it. The definition of commercial activity is very broad. This is your takeaway. It applies to any transaction, act, or conduct. That means suggested that it does not have to be an exchange of any sort. And that means it applies to nonprofit activities and it applies to charitable funds. Okay, that's commercial activity. It covers nonprofit activities and it covers charitable funds. That is not just my opinion. That is something that not only many other lawyers in this area will tell you, but more significantly, that is something the CRTC has said. Okay. So, do charities and NPOs transmit CEMs? The answer is absolutely. Okay. Here are some examples of CEMs sent by charities and nonprofits. This is just me coming up with some examples. There are many more. Okay. Email seeking donation. That is a CEM. Email selling tickets to an event or a lottery. That's a CEM. Emails promoting services of the NPO or the charity. That is a CEM. Emails promoting a charitable event or activity. Emails promoting the organization itself. If you're promoting your organization and your charity, that's a CEM. And finally, e-newsletters, also CEMs. I'm saying this because not only, again, is that was my opinion a long time ago when this started, but that is something that CRTC has confirmed. Now, what is not a CEM? What does not fall under that? Well, very little, unfortunately, because of the very broad definition. However, I can comfortably say that if the message you are sending out is purely educational in its purpose and content, okay, purely to educate. For example, you're sending out some kind of a newsletter that solely talks about maybe you're a charity that raises funds for a certain type of health issue, a disability, etc. And there's a new drug on the market or treatment on the market, or not even the treatment, actually, that already will be a CEM, but maybe you just want to educate the public about this particular disease or this particular disability, and it's purely educational, and there's nothing in there that says, oh, and by the way, to find out more about us, click here, or by the way, you know, to give us money to help save lives, etc., click here. It's purely to educate. In that case, it's likely not a CEM. Okay, so now that we know what CEMs are, everybody, I mean, some of you I'm sure are going, what? Oh my God, oh my God, oh my God. Then what? So you said CEMs, so what? Well, here's what CASL says about CEMs. Here's what you have to do with respect to each CEM that you send out. Basically, CASL has 3 CEM requirements. The first one is, well, actually, let me step back. Basically, CASL says you are prohibited. You cannot send that CEM. You cannot click send, okay, unless 3 things are present. First of all, the receiver of that CEM has already consented to receive it. In other words, this is an opt-in regime. CASL is opt-in. They had to have opted in before you click send, okay? And that's very important. Second, the CEM has to contain certain prescribed information. And one of my other slides will tell you what the prescribed information is. And finally, the CEM has to contain an unsubscribe mechanism. Again, I will break those 3 down in my presentation. Let's talk about the first requirement, consent. The most important, frankly, I would actually, no, not the most important. They're all equally important, but this one is where people have trouble complying. It's the hardest thing to comply with. So, first things you need to know is a CEM may only be sent with the recipient's express or implied consent. So we have 2 types of consent. We have express consent, we have implied consent. And again, I'm going to break those 2 down for you in a couple of slides. First of all, the other thing you need to know is CASL places the onus of proving consent on the sender. So if someone files a complaint against you and says, oh, I never consented to this, okay, it's not up to them to prove that they didn't consent. It's up to you to prove that they did consent. You see how that works? And that puts a burden on you to keep track of things, right? And finally, an electronic, this is the key, an electronic message requesting consent is a CEM and is therefore prohibited. What does that mean? Well, basically, if you say, oh, I want to get consent from all my members or my, whoever I'm sending these emails to, I'm not sure if I have consent from them. Well, why not just send them an email and ask for their consent? Can't do that. CASL says that email saying, hey, give me consent to send you CEMs is prohibited. You can't do it. You could have done it before CASL came into force, before July 1st, 2014. Not anymore. So let's talk. Remember I said there's 2 types of consent, express consent and implied consent. Let's focus on express consent first. What is that? Express consent is basically someone telling you, yeah, I consent, send me CEMs. Okay? That's basically it. Now, CASL allows you to get that express consent in orally or in writing. It doesn't have to be in writing, it could be oral. Of course, there's an issue of as a lawyer, I always say oral is not a great idea. I would recommend against it because, as you know, how do you prove it, right? It's so much easier to prove it's written, it's much harder to prove if it's oral. And when you get consent, when you ask for consent, when you ask someone for their consent, you have to include specific requirements in that request. I don't go into the specific requirements here simply because I don't have the time, but of course if you contact me, and I'm happy to give you that advice. Now, let's talk about implied consent, okay? So, yeah, sorry. Express consent is where someone tells you, we consent. What if they haven't told you they consent? Well, there are other ways you can get consent, and that is through implied consent. Now, some of you who are familiar with the privacy laws, maybe not, you would know that in privacy law, there is also implied consent where, you know, you have certain implied consent under the law to collect someone's information, to share it, etc. What you know about privacy law, put aside because it's not the same, okay? Basically, actually, what I would say is CASL makes it easier to understand because CASL very clearly sets out in the legislation and it sets out specifically when and what circumstances you have implied consent. Okay, it's sort of very black and white. If it meets this circumstance, it is. If it doesn't meet the circumstance, it's not an implied consent. And so you need to understand when you have it. What are those circumstances? And then you can decide whether or not you have implied consent. So there are a few different ways in which a charity or a nonprofit can get implied consent. And the most common one I deal with my clients, and again, I've had numerous clients or many clients that work for charities and nonprofits, is what is called the non-business relationship implied consent. What is that? Keeping it simple, it basically means that a sender who is a registered charity, so it has to be registered charity under the ITA and the Income Tax Act, has implied consent to send emails to the recipient who had made a donation to that charity or performed volunteer work in the preceding 2 years. So in other words, 2 years before that email was sent, that person to whom you're sending the email has either donated to you or did volunteer work. So that's for registered charities. What about nonprofits? Nonprofits also have a non-business relationship, implied consent. And what CASL says is if the nonprofit organization and the recipient, the nonprofit organization has implied consent to send emails to anyone who was a valid member of that organization in the 2 years before they sent that CM. Okay, so again, you click send. The recipient must have been a member of yours in the 2 years before you click send. Okay, now that's good, right? Well, let's talk about when that actual 2 years starts to run. So for charities, okay, that 2 year period starts to run every time, or at the last date of donation or volunteering. So if someone donates regularly every year, that 2 years period starts again. Okay. Same for volunteering. If someone volunteers every month, that's got a 2 year period starts the last time they volunteered. All right. And for nonprofits, it actually is even a better, sort of a longer period, because CASL says that the 2 year period starts to run when the membership is terminated. So as long as they're current members, that 2 years doesn't even start running. So it's only when they terminate their membership, you still have implied consent to communicate with them or to send them CEMs for another 2 years. Okay. Now, there are other prescribed circumstances for implied consent, such as an existing business relationship, a conspicuous publication implied consent. I am not covering it in my presentation today simply because they take another 10 to 15 minutes to cover, and we just don't have the time. But again, happy to discuss those with you if and when you contact me after this presentation. Okay, but I want to focus on the non-business relationship, because that is the main one that most charities and nonprofits rely on to communicate, to send CEMs. Okay, so again, remember, if you're a charity, you have 2 years implied consent to communicate with anyone who donated to you in the 2 years preceding that email or that CM, or volunteered for you in the 2 years preceding. And if you're a nonprofit, you have implied consent to communicate with anyone who was a member of your organization in the 2 years preceding that sending of that email, or sorry, terminated the membership in the 2 years preceding the email. So that implied consent is the good news, right? I think some of you might be even breathing, having a deep breath and saying, oh, okay, this is good, this is good. Well, yeah, it is good. That's sort of one of the things that most of my nonprofit and charity clients rely on. But there are warnings that I need to give you, and I give to all my clients about relying on implied consent. There's a few problems with implied consent. First of all, it's not indefinite, right? It's definite. It has an expiration date, right? It expires at the end of the relevant period. And I say the relevant period because it's 2 years, essentially, but that 2 years depends on when it starts to run, right? So you need to figure out when it stops. Okay, when it starts, and you need to track that relevant period. So that's important for your for when you comply with CASL. You want to make sure you have a tracking system. Now, you have implied consent doesn't mean you're exempted from complying with the other CASL requirements. And the other CASL requirements, which I'll get to, are prescribed information and unsubscribe mechanism. You still have to include those in the CEM, and if the person unsubscribes, guess what? You have to take them off your list. You cannot send them. You no longer have implied consent. That implied consent is over as soon as they opt out. Okay? All right, so that's why I would say you must implement a request to unsubscribe by individuals who give you implied consent, with whom you have implied consent. Now, let's talk about the other reason why. Remember I said there were two bases why July 1st, 2017 matters. The first one was the private right of action. The other one is the transitional period, and that applies to implied consent. What do I mean by that? So Sorry, I don't know if you guys can hear, but my office phone is ringing. I thought I turned it off. Apologies if it's interfering. The 3-year transition period was something that the government put into play to help organizations such as yourselves kind of catch up with their consents, getting consents from their members and their donors, just basically giving you an extra year. All right, give you a 3-year transition period to July 1, 2017. But it's not as clear cut as that. Here's how it works. Okay, CASL says that for parties who were in an existing in your business or non-business relationship, in your case it's a non-business relationship, prior to July 1, 2014, and we're sending CEMs then, they have implied consent until July 1, 2017. Basically what that means, simple terms, that charities have, charities and nonprofits, charities have implied consent to send CEMs to their former donors that volunteered until July 1, 2017. And nonprofits, and my apologies it's not there, but it's the same thing. Nonprofits have implied consent to send CEMs to their pre-July 1, 2014 members until July 1, 2017. Complicated? I think I need to break that down a little more. Let me explain. So, by way of example, let's say you're a nonprofit, and I'll give an example for a nonprofit and then for a charity. So for a nonprofit, a non-charity, you have members that, old membership from, going back, way back, okay? And you have members who were members of yours maybe in 2012, okay? And they terminated their membership in 2012. But they're on your contact list and you're sending your CRM and you're still sending them emails. You're thinking, oh my God, can I send this in emails? Well, the good news is yes, you can, but only until July 1, 2017, because the transitional period said that so long as they were your members before July 1, 2014, anytime before July 1, 2014, you have an implied consent to send them CEMs until July 1, 2017. But starting July 2nd, 2017, you better stop sending them emails, because at that point you're violating CASL. Same for charities. Charities, you're a charity, someone donated to you in 1997. Okay, maybe I'm going a little 20 years back. Let's be a little more current. Let's say someone donated to you in 2011, and they haven't donated since. Okay, but they donated to you. They're on your CRM. You constantly send them requests for donations every year, etc., etc. Let them know what you're doing. Okay. Oh no, are you violating CASL? Well, not currently, because as the transitional period says, you have implied consent to send them CEMs until July 1, 2017. Anyone who donated before July 1, 2014 is now falls under that umbrella. But starting July 2nd, 2017, you better stop sending them those emails, because at that point you're violating CASL. Okay? So that's the transitional period. I know it's complex. I'm happy to discuss it with you one-on-one if and when you contact me after this. Okay, so that's the consent requirements for CASL. And I'm sorry I'm rushing through it, but we only have 20 more minutes, and I need to cover all the other requirements. So what are the other 2 requirements I mentioned earlier? The first one is the prescribed information. Every CEM has to include the following, okay? The name, mailing address, and either an email address, a telephone number, or website for the organization. I presume most of you do that, right? So not a big deal. It also has to have a means by which to contact the sender that's effective for at least 60 days. In other words, the email that's there cannot be just a general email box that sort of goes to nowhere. It's got to go to the sender. And then finally, an unsubscribe mechanism. It's got to be in there, right? In the actual email. And again, I'll get to the unsubscribe mechanism. What does it mean? But it has to be in the email. Now, sometimes that's a lot of information, and you don't want to include all of that in your email. Well, the CASL allows you to do that by saying that if it's not practical to do it, then you can actually post all that stuff on your website and then have a link to the website, but in your CEM. But that link has to be clearly and prominently set out in the message. Okay, so that's easy. Most of you probably already have that information requirements. But what about the unsubscribe mechanism? Let's talk about that. So as I mentioned, every CEM has to have an unsubscribe mechanism in it. And what is it? First of all, it has to be sorry. Let me see just a minute, I think. Yeah, okay. I'm sorry, but there's a couple things that are missing in that slide. I think they may have been deleted, and I apologize. I'll just tell you. So first of all, an unsubscribe mechanism is a mechanism by which the basically put what it says, okay? A mechanism that allows the recipient to unsubscribe from receiving CEMs from you on a go-forward basis. It's basically a way for them to say, don't send a CEM anymore. Opt-out. Okay, it's an opt-out. But a couple things that has to be in there. First of all, that opt-out, that unsubscribe mechanism has to be done electronically. Okay, in other words, you can't tell them, oh, to unsubscribe, please print this, sign, and send it by mail or fax it to us. No, it's got to be done by an electronic means. Okay. So it could be done by way of clicking on something, or make it just as simple as an email. Okay, I for example, have an unsubscribe mechanism. When I send emails I send CEMs out. In the bottom of my email, it says, to unsubscribe from receiving CEMs from my firm, please reply to this email with the word unsubscribe or opt out in the subject matter, and that's it, and I'll unsubscribe. Okay, but that's fine. Okay, that's an electronic way of subscribing. The other thing you need to know about the unsubscribe mechanism is it's got to be effective for 60 days. That means that in the 60 days following the sending of that email, that person can go back and unsubscribe. So maybe they don't want to unsubscribe now, but 20 days or 30 days later, they say, oh, you know what, I don't want to get any more emails from that. I'm going to go and unsubscribe. So if you're providing them with like a link in which they can click to unsubscribe, that link has to be still be effective, and they have to be able to access it in the next 60 days. Here's the kicker though. Here's where people fell, and a lot of the companies that have been fined so far have fallen on this one. Is the unsubscribe mechanism has to be given effect within 10 days of the request. So as soon as someone says opt out, don't send me any emails, that's when the 10 days starts to run, and within that 10 days you better put not send. Sorry, actually I should put it differently. From that moment forward, you have 10 days to send them CEMs. After that, it's done. Don't send any more CEMs. And the unsubscribe mechanism has to be done at no cost to the requester. I doubt that applies to you guys, but it's that's just there because some people or some companies at least find that if they say, oh, to unsubscribe, click. So a cost could be different things, right? So oh, if you want to unsubscribe, fine, but that means you won't get any more. I don't know. You want to get something from us, right? We won't do whatever it is. We won't do business with you or something. So that should not happen. They should be doing it and not have to suffer any consequences. Now, I want to focus for a couple minutes on the unsubscribe mechanism and explain why I think it's really important, right? In essence, and this is just common sense, okay? The unsubscribe or the opt-out is someone telling you, I don't want to get emails from you anymore. I don't want to hear from you anymore. Okay, stop sending me emails. Okay. Now, I have a lot of clients who really can't get their head around this. They will figure out ways in which to discourage people from unsubscribing. They're really scared of the unsubscribe. And so they'll think of, okay, and by the way, there's different ways in which you can tailor the unsubscribe, right? It doesn't have to be unsubscribe from all emails. You can say, and I've had, again, Charities and clients ask that, and I say that's totally fine. You can give them options. You can say, okay, click here to unsubscribe just to our newsletter. Click here to unsubscribe just to whatever, volunteer request, whatever. You can do that. You can certainly tailor it. But you also have to give them legally the ability to unsubscribe from all CEMs, okay? And that's important. But in any event, whether you tailor it or you don't, it's so important that you give effect to that unsubscribe mechanism as soon as possible. In fact, I'd say right away. Because there's someone telling you, don't send me emails. And so if you are going to send them an email afterwards because you think, oh, well, it doesn't matter, I'm subject to the charity exemption, which you may be, we'll talk about it in a minute. So if you're subject to the charity exemption, if they unsubscribe, you still technically can send them CEMs. Why would you want to do that? And you need to think that through. Say, well, if this person said they don't want to hear from me, they're probably not going to donate to me. Okay, so I may as well just give effect to this and, take them off my list. All right, so just keep that in mind. Now, let's talk about exemptions. So that's before I go on to the exemptions, I just want to kind of summarize. So as I mentioned earlier, basically the three requirements to comply with CASL are as follows, right? You have to make sure that you get consent before you click send, okay, and that consent could be either express or implied based on what the CASL says, what is implied consent. You have to include the prescribed information that I mentioned earlier, the identifying who you are, etc., and you have to have an unsubscribe mechanism in each CEM. So now that's the requirements. When don't you have to require with CASL? When do, even though you send CEMs, when do you just can ignore all these? Well, the good news is when, if you meet one of the listed exemptions in CASL, you don't have to comply with these requirements. And CASL has various exemptions to it. There are two sort of very broad, I put them into two broad categories. The first one is the complete exemptions. Basically, if you meet these circumstances, and they're very, very specific, if you can meet these circumstances, you are entirely exempt from complying with all the requirements. You don't have to get consent, you don't have to include the information, you don't have to unsubscribe. And it also means that if someone unsubscribes, you can still technically send them emails, although, as I mentioned earlier, probably not a good idea. Partial exemptions. Partial exemptions are certain circumstances. Again, if you meet those exemptions, you don't have to get consent. That's a good thing. But you still have to include the information, and you still have to have an unsubscribe mechanism. And if someone unsubscribes, you have to take them off your list. Okay. So you have, if you want to rely on these exemptions, okay, to continue sending CEMs to certain individuals, all right, or certain recipients, the onus is on you to prove that you meet the requirements of CASL. And CASL is defined, well, CASL in terms of the CEM, definition of CEM is very broad. When it comes to the exemptions, for obvious reasons, they define them very narrowly. So there's very narrow circumstances in which you can meet these exemptions. Now, there's a whole list of exemptions, but I don't have time to cover them, right? And now we're down to 15 minutes. So what I'm only going to focus on today is what matters, what is most, what most of you are going to be relying on, and by most of you I mean the registered charities. Nonprofits that are not registered charities, apologies for the next 5 minutes when I talk about the registered charities exemption. It doesn't apply to you, so hopefully you'll just wait around until we get to the rest of the presentation. So certainly, as I mentioned earlier, if you want to talk about other exemptions, and there are more exemptions, again, at the end I'll tell you how you can get that information when you get in touch with me. So let's talk about the registered charities exemption. What is that? It's an exemption that says that any CEM sent by, and again, I'm paraphrasing this, okay, it's very specific language, but this is how I paraphrase it. CEM sent by or on behalf of a registered charity, again, that's a registered charity under the Income Tax Act, and the message has as its primary purpose raising funds for the charity. Those are the words. The message has as its primary purpose raising funds for the charity. That's directly from the exemption. If the charity meets that, if the CEM meets that exemption, meets this test, meets this definition, then you do not have to comply with any one of CASL's requirements. Great, right? Well, I guess so. So let's break that down. First of all, you have to be a registered charity. As I mentioned earlier, it doesn't apply to nonprofits who are non-registered charities. Second of all, and this is so important, and I put it in bold and capitalized because this is something that often charities who come to me don't understand. They seem to think that they're subject to an exemption. Oh, we don't have to comply with CASL, we're exempt. No, it's not a blank exemption. It doesn't apply to all CEMs sent by a charity. It only applies to certain CEMs. Okay, not all. So you need to really focus on the type of CEMs you're sending and what is the content, what do they actually say if you want to rely on that exemption. And I'm going to break that down for you a little more. So first of all, as I mentioned earlier, the wording is the message in that CEM, the content of the CEM has as its primary purpose raising funds for the charity. Well, first of all, what does raising funds mean? Well, according to Industry Canada, they would define raising funds broader than fundraising. And some of you, your charities be aware that there's a definition of fundraising under the CRA that the CRA has defined. So, according to Industry Canada, raising funds covers more than that. It covers more than just fundraising. It covers sale of tickets and services, for example, to galas. And as long as the funds are intended for the charity and not for another recipient, it will be raising funds for the charity. Okay, so that's a good news because that means it's a little bit broader than fundraising. But here's where the definition becomes narrow. The primary purpose. What does it mean when the content of a CEM is the primary purpose of it is raising funds for the charity? Well, according to the CRTC, and this is what they said in their online, and again, this is all we can get from them, is the primary purpose of the CEM means the main reason or main purpose of the CEM. Okay, there could be a secondary or additional purpose for the message, but the principal purpose of the CEM must be to raise funds for the charities. That's their words. I'm just quoting what they said. What does that mean? I don't know if they made that any clearer. Personally, I don't think so. But that's what the CRTC, how the CRTC defines or interprets primary purpose. They go on to say as follows, okay? Given that legitimate messages sent by registered charities raising funds are exempt under the Act, and here's, I highlighted this part because I think it's important. The CRTC will focus on messages sent by those attempting to circumvent the rules under the guise of a registered charity. What does that mean? Essentially what they're saying is, you know, if you are going to, you as a registered charity are trying to basically exempt yourself entirely from CASL, that's not going to work. Okay, you need to be clear and understand that when you send out those CEMs, they have to be for the primary purpose of raising funds for the charity, or they're not going to be subject to the exemption. You can't, in other words, the CRTC is going to look behind what you're doing and say, are they kind of trying to trick the system by making it sound like it's for the primary purpose of raising funds, but it's actually for something else? We're going to go after that. Okay. Now, the CRTC has also said that e-newsletters sent by charities may be exempt if they contain a request for donations or a logo. Sorry, again, apologies if there's a sound in the background. My phone is just not close to where I'm sitting, so I can't turn off the ringer. I'll get back to this. E-newsletters, they could be exempt if they contain a request for donations or a logo of a corporate sponsor, but they won't be exempt, again, this is what the CRTC says, if they promote or advertise commercial activity that is not of the charity. So again, think about your e-newsletters. You send out e-newsletters, and you know, in that newsletter, you're asking for donations, great, but that might exempt you. But if you are adding other stuff in there, where somehow directly or indirectly you're promoting commercial activity, whether it's the commercial activity of the charity or of someone else, like a corporate sponsor, at that point it's not exempt. And if it's not exempt, you've got to get consent. What does all this mean essentially from a practical perspective? Here's my warning to you. It is, oh, actually, let me get back to it for a minute. First of all, where I read this is to say, okay, the CRTC is trying to send a message that they are going to be not as harsh on charities as there was initial concern, okay? They're going to say, okay, as long as you can show that somehow the purpose of your message is to raise funds, we're going to let you off the hook, and you're not trying to get, you know, to trick the system. We're going to say it's okay, it's exempt, right? That's basically what the CRTC is saying. So that's good news. But here's my warning. It is questionable, that's my opinion, okay, only my opinion. It is questionable whether the primary purpose test would be interpreted and applied the same as the CRTC by a court in a civil action. What do I mean by that? Okay, well, you know, we don't have a court decision. And so when I talked about as of July 1st, 2017, you may be sued by individuals, that means the CRTC doesn't get involved. It's pure, well, the CRTC is actually involved indirectly, and I'm not going to get into the details. But at the end of the day, it will go before a court, and the court will decide how it interprets the primary purpose test. Primary purpose of this. And the court might not agree with the CRTC. They might say, no, we think it's got to be the sole purpose, the only purpose, the main purpose of to raise funds. And if there's something else in there where you're doing something other than raising funds, we're not going to exempt you. So I'm just warning you and saying, well, take the CRTC's opinion or CRTC's guideline that I gave you earlier here with a grain of salt, because it doesn't necessarily mean that it's going to apply in all cases. And my concern is, if it goes before a court, and I, as an admin tribunal, person who sits in the administrative tribunal, I myself interpret legislation all the time. I can tell you that there's no real, without precedent, without a court decision, it's hard to really figure out how a person who's interpreting this for the first time will interpret it. We just don't know. So my concern is that the primary purpose may be interpreted from the point of view of the receiver of the email and not the sender. Okay, so you're going to say, oh, but the primary purpose of this was to ask for money for to raise funds for the charity. But the court's going to look at this and say, no, we actually think that we're going to look at it not from your point of view, what you're saying that, but what the receiver is reading this and thinking something completely different. And in that case, you may not be exempt. So, what is my best practice recommendation to you if you're a charity? Well, first of all, I recommend to all my charity clients not to rely exclusively on the charity's exemption. In other words, don't just assume that you're exempt, period, then just can do whatever I want. No. don't do it. Why? Because as you see, the exemption is narrowly defined and there's question marks on how it will be interpreted by a court. Second of all, develop and implement a consent-based policy, okay? In other words, try to get, develop your CASL compliance policy not based on the exemption, but based on consent. And if you choose to rely on the exemption, do so only for CEMs that are for the primary purpose of raising funds, first of all, of course, and designate a qualified person. It could be a legal counsel, a compliance officer, or it could just be your marketing person who understands and is trained on CASL. That person will vet the CEMs. Okay, so you're going to say, okay, now we're putting together an email that's going to go to all whoever it is. It is a large email that's for whatever your purpose it is. That person will look at it and say, I think we should use the following words to ensure that we meet the primary purpose test, and that way we don't have to get consent from these thousands of people we're sending the email. Okay, I got 5 minutes, so I want to go forward very quickly. And I'm going to give you very, very briefly recommendations for CASL compliance to all of you. This is not just to Charities, this is to all of you. Okay, first of all, get your board on board, okay? Decisions respecting CASL should form part of the organization's overall risk management strategies, okay? Just like any risk management decisions that you make, you need to consider CASL. Why? Because I started out telling you the kind of risk you're facing if you violate CASL. And because of that, because of the high-level risk, including the D&O liability, direct and office liability, decisions should be made up top level. They shouldn't be left to someone who's on the ground, maybe drafting emails, or maybe a marketing person. It's got to be made by the board. It's got to be made by your executive, or they at least have to be involved because it is a risk management decision. So if you can't get the board to pay attention, remind them about the director and officer liability, director personal liability under CASL. 2, conduct an audit. Conduct an audit of the type of communications, electronic communications you do, who to whom, what type of communications you send, etc., your contacts, your list, etc. And then there's a whole list of stuff that you need to think about, and I'm not going to go through it, but you can read it later. Okay. 3, develop and implement. I'm getting back to the most important part. Develop and implement CASL compliance policies and procedures. Why? Remember, due diligence defense. If you do that, you have a defense to rely on in case the CRTC knocks on your door, or if you are sued in court. So here's some suggestions about what your policies and procedures, your CASL compliance procedures should include. And again, I'm not going to go through them because we have 2 more minutes. Training and education. It's not enough to have a CASL compliance policy, as I mentioned earlier. It's not enough just to have that on your website or have it in writing. You actually have to train and educate your employees, your volunteers, anyone who's actually communicating on your behalf, including third parties, by the way. There's lots of third parties that would communicate on your behalf. And those are people who need to be trained as well on your policy. Review contracts you have with third parties and make sure that you require them to comply with CASL if they're communicating on your behalf. That's, for example, your marketing people, your external marketing people. Consider buying insurance for CASL. That's important. There's insurance against CASL, D&O, and just regular insurance. Keep that in mind. And consult with IT specialists if you can, and I certainly can recommend some if you contact me, who deal with it specifically and know how to tailor your communications and your systems, your CRMs, your email systems to comply with CASL. And again, I can't get into it right now, but happy to discuss at another time. Okay, I'm listing here on these, and I'm just going to click through them. These are slides to deal with the other. Remember I said there's not just CEM requirements, there's other requirements under CASL. I don't have time to talk about them, but they're there, and I put them there so you can take them home and read them. But just a quick review, talking about email, electronic collection, and address harvesting, okay? So it basically deals with collecting email addresses online without someone's consent, and you need to understand what that means. And again, I'm not going to get into it. You're welcome to read it. Okay, so we have 1 more minute. Let me just tell you what to take from this, since we don't have time, and unfortunately I don't have time to take questions, and I'm not surprised because it's a lot I wanted to cover as much as I can in the 1 hour. So a couple things you can take away. First of all, how can I help you, all right? And there's a few ways that I can help you, and I list a few ways there. Just a second, I'm just trying to move my, there we go. This is this kind of stuff I do for my clients, for my nonprofits and charities. I help with the audit. Okay, auditing current and future practices, advise, give advice on developing and implementing CASL compliance, drafting and reviewing your compliance policies, drafting your third-party contracts, compliance training, and representing you before a regulator or court if you are unlucky to actually be faced with that. Now, question. So what I've done, because we don't have time, is as you can see there, that's my website and my contact info. That website will change in a few weeks to a new website, as I mentioned, because I just started a new law firm and we're going to have a new website. But in the meantime, you can find me there. That's my email, my 2 different emails. You can reach me either one, and my phone number. Why do I put that there? Because we don't have time. What I'm doing as a courtesy to anyone who has attended here, if you would like to contact me, and there's going to be a questionnaire, I'm happy to set up a consultation, and I give very, and I'm going to say reasonable is beyond reasonable, very discounted rates for a 1-hour or 2-hour consultation, whatever you want, with you, with your team, with your board. I do that especially for people. You're going to tell me you attended this webinar, so you get a special rate, a discount, and I will answer your questions. I'll take you through more details of the various exemptions, etc., and various matters that are relevant to you and CASL, and I will certainly try to, in that amount of time, or the hour, the 2 hour that you choose, to answer as many questions as you have regarding your organization. And again, will be a very, very discount rate. I'm not going to say what it is, but it's discounted. So without further ado, I'm going to give this back to Joyce, and sorry again for not being able to take your calls. It's exactly, sorry, your questions. It's exactly 1 o'clock.
No worries, and I'm not going to speak for too long because I know my audio is terrible, but I want to thank you again, Maanit, and thank you everyone for joining us. Again, this webinar is being recorded. It will be available on our website, and the slides are currently available for download as well. Thank you again, everyone. Have a great rest of your day.
Have a wonderful day, everybody. Thank you for attending. Take care.
Bye.